Gulistan and had his home there. We submit that the substantial evidence before the court, including detailed statements from members of the family and other villagers, confirms beyond any doubt that prior to their expulsion, the Sargsyans were living in their home in Gulistan, and also establishes Mr. Sargsyan's ownership of his house and land. Minas and Lena physically built the house themselves. They kept livestock and they grew fruit and vegetables on their land. Contrary to what the government has tried to suggest, Minas Sargsyan was the legal owner of the property. He had applied to the village council in the early 1960s to register the division of his father's land and other property with his brother. This was then recorded in the village council register, and he and his wife built their house on that land. A number of witness statements from villagers, including a member of the board of the village council and a villager who was secretary to the village council for 24 years, confirmed that this was the procedure adopted in the village and that it was the procedure actually followed in Minas Sargsyan's case. The allocation of land plots in the early 60s was regulated by the 1958 Charter on Village Councils, which vested village councils with the power to allot and allocate land within villages and register and record the division of households. The government is simply wrong to suggest that village councils were not empowered to allocate land. The government has repeatedly referred to the 1970 Land Code, which by definition was not in force in the 1960s. As to the 60s, the government simply says that there was an absence of specific laws at that time, and that prior to 1970 the only laws regulating property rights were the constitutions of the USSR and of Azerbaijan. To prove his ownership, Minas has produced his technical passport, which incorporates a plan of the house and a specification of his plot of land. The government acknowledges that technical passports were only provided to people who had legal title to the property in question. However, the government tries to suggest that Minas Sargsyan's technical passport was deficient and even alleges that it is a falsification or a forgery. On the contrary, it is perfectly valid, in compliance with both the established practice at the time and the relevant domestic law, namely the 1985 instructions, which specified that in rural areas the basis for registration of homes were the household lists held by the village councils. Furthermore, as Minas had the right to use his land, he automatically became the owner of it in 1991 by virtue of the 1991 Land Code. As the Sargsyans have been denied access to their home and land since 2002, they've effectively lost all control over their property as well as any possibility to use and enjoy it. There is no evidence establishing that the Sargsyans' house has been destroyed, as at 15th April 2002 or subsequently. Indeed, one villager states that in August 2010 he was able to observe through binoculars that Minas' house was still standing, albeit with a dilapidated roof. Minas remains the lawful owner of the house, land and other property. The continuing denial of access is an interference with his rights under Article 1 of Protocol 1, and there is no legal basis for such an interference, and certainly not one that is publicly available. The government refers to a Ministry of Defence order forbidding access to the village, which is secret. There is no justification for the complete negation of the Sargsyan family's property rights in the form of a total and continuous denial of access without compensation. And for the same reasons, Minas and Lena Sargsyan's rights under Article 8 have been and continue to be violated. They built their house in the early 1960s and they lived there for 30 years before they were forcibly expelled. And while he was alive, Minas constantly reiterated his intention to return, as did Lena. Mr. President, I now give the floor to Ms. Gasparian. Thank you.
Mr. President, I am going to address the Court on Article 8 and Article 13. Firstly, on the applicant's victim status and the merits of his Article 8 claim relating to the grave of the applicant's relatives. The applicant submits that the continuing lack of access to his relatives' graves in Gulistan and the failure to respect this positive obligation by adopting measures designed to protect and maintain the graves of relatives in Gulistan, cemeteries engage the right to respect for his private and family life. The court's case law, including Eli Pahuas and Adri Vionnet, confirm the applicability of Article 8 in comparable situations. In Abdullayeva versus Russia, the court found a violation of applicant's Article 8 rights as a result of the refusal of the authorities to return her son's body for burial. Article 8 was explicitly found to be engaged by the refusal to permit her to visit her son's gravesite. In Panola and Forte versus France, the court found the excessive delay by the authorities in returning the body of the applicant's child following an autopsy a violation of the right to respect for their private and family life. Mina Sargsyan's father and 3 sisters, and Lena Sargsyan's parents and sister are buried in Gulistan cemeteries. It is not disputed that the applicants have had no access to Gulistan and the graves of their relatives since they had to flee the village in 1992 and subsequently after the ratification of the convention in 2002. The Sargsyans have therefore been unable to visit or take care of their relatives' graves since then. The Sargsyans used to regularly visit and take care of their relatives' graves. Attending the gravesite and respect and dignity for the deceased were taken very seriously by the Sargsyan family. Mina Sargsyan said in 2008, "I am a Christian and faithful person, and I consider it a sin that I cannot take care of the graves of my ancestors, cannot go and light a candle, visit the graves on Easter and respect their memory." Lena Sargsyan said in 2010, "Every year on May 2nd, the whole population of the village used to go to the cemeteries as a tribute for respect for the dead." We submit that the positive obligation inherent in securing effective respect for the Sargsyan's private and family life require that the government should have taken necessary steps to ensure the protection and maintenance of the Gulistan cemeteries. The government has failed to provide any information about any measures it has taken to maintain or safeguard the graveyards, including, for example, protecting them from deterioration caused by vegetation or weathering, or acts of vandalism. In spite of the court's request in 2007, the government has failed to provide any information whatsoever as to the current status of the cemeteries in Gulistan. This has caused the applicants great uncertainty and insecurity as to the fate of the graves. The applicants' submissions as to the positive obligation of the government are made in the light of the evidence of the damage or destruction of Armenian graves and historic monuments in Azerbaijan. For example, in 2004, the European Parliament called on the Azerbaijani authorities to put an end to the demolition of Armenian cemeteries in Nakhichevan. We therefore submit that the applicants are directly affected by being prevented from visiting the graves of their relatives in Gulistan, and the government's failure to respect its positive obligations to protect and maintain the Gulistan cemeteries. The continuing interference with the applicants' Article 8 rights are not lawful, does not pursue a legitimate aim, and is disproportionate. Mr. President, I will now address the question of domestic remedies and the merits of the applicant's Article 13 claim. The burden is on the government to satisfy the court that any purported domestic remedy was effective and available in theory and in practice at the relevant time, that it was accessible, capable of providing redress in respect of the applicant's complaints, and offered reasonable prospects of success. This burden of proof has never been satisfied. What evidence does the government rely on? There is a brief Ministry of Justice statement asserting that between 1991 and 2006, the courts in Baku delivered judgments in 243 civil claims of ethnic Armenians, 98 said to be relating to housing disputes. However, there are no further details of those cases except for 2. The first is the Mamadova case, which concerns the inheritance rights of a US citizen, and the second Chagarian case, which is about the hereditary succession. Both cases are quite irrelevant, not in any way relating to Armenian displaced persons who were expelled and lost their homes and land during the conflict. The government has not provided a single example of successful legal claim brought by someone in the Sargsyan's position. Then, in October 2012, in responding to the applicant's claim for non-pecuniary damages, the government made its first reference to a body called the State Committee for Refugee and IDP Issues of the Republic of Azerbaijan. It suggests that it would have been possible for the applicant to have applied to this body for support, without specifying what is meant by support. There are no details at all as to what powers this body has or what steps it has actually taken and for whom. Government fails to refer to any specific cases in which the committee has provided support, whatever that may mean, and certainly not to an ethnic Armenian refugee. In Agdeva, the court underlined that in applying the domestic remedies rule, realistic account must be taken of the general legal and political context. There are no diplomatic relations between Azerbaijan and Armenia, and ethnic Armenians cannot obtain visas. The evidence before the court shows that in practice visas are only granted to Armenians where they are participating in official visits organized by international organizations or diplomatic missions. And in such cases, Armenians have needed to be provided with armed guards. Under the Civil Procedural Code of Azerbaijan, the domestic courts have the right to require a claimant to attend in person in order to present their evidence, and it also requires witnesses to appear before the court in person. This would not have been possible in practice for ethnic Armenians. Instead of simply asserting there are no property records and alleging that Mr. Sargsyan's technical passport is forged, for the reasons that Mr. Leach has explained, there are positive obligations on the government towards someone in Mr. Sargsyan's position. It has jurisdiction over the area, and hence it is responsible for ensuring there is an effective remedy for the applicant to challenge his violated rights. The UN Plenary Principles confirm that the right of refugees to have restored to them any housing, land or property of which they were unlawfully deprived, or to be compensated for any housing, land or property that is factually impossible to restore, as determined by the independent, impartial tribunal. The principles also provide that the right to restitution should be prioritized as to the preferred remedy. They also require that the state to establish and support equitable, timely, independent, transparent and non-discriminatory procedures, institutions and mechanisms to ensure that everyone unlawfully deprived of their home is able to submit a claim for restitution or compensation to an independent body and to receive a determination. Look at the contrast as regards Greek Cypriot property claims in northern Cyprus. In Demopoulos versus Turkey, the Grand Chambers was finally satisfied with the revised provision of the domestic redress on the basis that the Property Commission had been functioning for 4 years, it was sufficiently independent, it had made decisions in significant number of cases, including awarding millions of euros in compensation and ordering the restitution of property. The Commission took a reasonable length of time and was subject to a right of appeal to a high administrative court. The Azerbaijani authorities have failed to establish anything remotely comparable to this. The government simply asserts that it is unable to provide alternative housing to the applicant since the applicant is not under its jurisdiction. However, the Plenary Principles confirm that the right of restitution of property is a distinct right, which is not prejudiced by the non-return of the refugee possessing property rights. Furthermore, states should ensure that restitution claims processing is accessible for refugees and displaced persons, regardless of their place of residence. The government has failed to undertake any measures to re-establish a housing and land registration system or a property records ICOF or any form of tribunal to receive and determine property claims from displaced